Good evening. My name is Elizabeth Anderson. I'm the Executive Director of ASIL, and it's a pleasure to welcome you here this evening to the first of our two-part Summer Associate Series here at Tiller House. This is at the headquarters of the American Society of International Law. Those of you who don't know us, we are the leading society of international lawyers here in the United States, some might argue even in the world. We publish the American Journal of International Law and International Legal Materials, and we hope will be your professional home as international lawyers. Those of you who are interested in membership, you can pick up that material, if not on your chairs, out here. And particularly while you're here this summer, we'd welcome you here at our Tiller House events. It's a wonderful way to learn more about international law, about different opportunities in the field, and to meet your colleagues. This evening, we are going to be exploring one area of practice in international law, a booming area, that is international arbitration. And we have two leading practitioners of that field with us. We're very lucky to have Lucy Reed and Jonathon Hamilton here. Lucy is a partner at Freshfields Bruckhaus Deringer, where she specializes in international arbitration, in particular investment treaty disputes. She has served as an arbitrator on the Eritrea-Ethiopia Claims Commission and also as co-director of the Claims Resolution Tribunal for Dormant Accounts in Switzerland, also known as the Holocaust Tribunal. Before her private practice, she was the first general counsel of the Korean Peninsula Energy Development Organization and had a career in the State Department as well, in the Office of the Legal Advisor, where she, among other things, was U.S. agent to the Iran U.S. Claims Tribunal and Deputy Assistant Legal Advisor for International Claims and Investment Disputes. Lucy is also, importantly, the President of the American Society of International Law this year and next, and we're blessed with her great leadership. We also have with us Jonathon Hamilton of White & Case. Some of you are working with him, I know, this summer. He is also a specialist in international arbitration, has practiced at White & Case in Washington, New York, and Mexico, and has advised private and sovereign clients on matters spanning more than 15 jurisdictions across Latin America, where much of his practice has taken place. We're very lucky to have them both. I think, Lucy, you will speak for a brief period, and then Jonathon, and we'll open it up for questions. Lucy.
Thank you. Start over. Thank you on behalf of the American Society, especially for all coming. I've spent the day here with Betsy working on various things and really looked forward to seeing you this evening. I won't go back over what Betsy just said, but the reason we do this is to give some background in different practice areas with an idea to some of the career issues that might be on your mind. So both Jonathon and I will spend perhaps a bit more time than we normally would on how we ended up doing what we do, which is practice in international arbitration and dispute resolution. The point I want to make on that, after Betsy's introduction, and this is going to be really depressing to you, is that I didn't really plan to do any of the things that Betsy listed that I did do in my career in international dispute resolution. Doors basically opened to different international tribunals and international law firm practices that I found interesting and was willing to hold my nose and take a jump and try. And in each one I was rewarded, not necessarily financially, all the time, but always professionally. And so my advice to young lawyers, particularly when they ask me, how can I do what you did? How could I negotiate with North Korea? How could I work on the Holocaust Tribunal? How could I do this? Is say, you'll never do those things because your opportunities for the next 10, 20, 30, 40 years are bound to be different than the ones that I, and in many ways Jonathon, were given. So my advice is keep your mind open, be flexible, and look for creative things to do in the area of international dispute resolution if that is something that interests you. And very briefly, I will tell you that when I left law school, I didn't plan to practice international law. I wanted to be a litigator. I was sure I wanted to do litigation. I came to DC and I clerked for 2 years for a federal trial judge here who ended up having only international cases, just about, including the first criminal trial involving the assassination of Orlando Letelier, the former Chilean ambassador who was assassinated right out here across the street in, when was that, 1978? Yeah, in the late 70s. And so Judge Parker, with whom I worked, did a year-long trial of an expatriated American and some poor Cubans who were participants. And at that time, no one ever dreamed that at the end of the day, the Chilean operatives, government officers who were involved in that assassination would be brought to justice, both in criminal court proceedings and in international arbitrations, and they were. So I was very interested in that, at that time, in international law, comparative procedure, all those issues, and I went to a law firm that was doing international arbitration in particular because the Iranian Revolution had happened, and the Iran-U.S. Claims Tribunal was set up in 1981, and my firm had, I think, 40 claims at that point in the special Iran-U.S. Claims Tribunal. And I also was doing other arbitration. And then when that was a firm called Wald, Harkrader, and Ross, which closed for various reasons, and I moved over to the State Department then to the litigation shop at the State Department, which we call L, for Legal Advisor's Office, and continued to work on Iran-U.S. Claims Tribunal cases and International Court of Justice cases, and ended up living in The Hague, doing it full-time at the Iran Tribunal and the World Court, and helped set up what was called the UN Compensation Commission, which is a claims commission that dealt with claims arising from the first Gulf War, with private claimants and public claimants. Very interesting and very successful process, unless you get into oil for food, which I won't get into. Then basically I went back in private practice when my husband, who had spent 3 years in the rather boring Hague, said that he would like to take a new job in New York City. So I moved to New York, and for the most part I've been back in private practice since then at Freshfields doing full-time international arbitration, having done claims work in the State Department before it was fashionable. And now it's more than fashionable, it's really the hot area, investment treaty disputes. And Jonathan will speak in more detail about investment treaty disputes, especially in Latin America. And what I propose to do is go over some of the other fora for international dispute resolution, which you ought to be aware of if you're interested in this field. So, to back up a bit, or to move forward a bit, international dispute resolution and arbitration is just what it sounds like. It's the resolution of disputes that involve nationals from different countries, or one national from one country and one state, or two states, or multiple states. But there's some cross-border or international component to it. And I know a lot of you are at White and Case, so you all, this summer, you'll already know this, but arbitration is not ADR. It's not alternative dispute resolution. It's not mediation. It's not negotiation. Arbitration is binding resolution of a dispute based on law decided by a finder of fact and decider of law. So it's very powerful medicine. Some people don't understand that. International arbitration, I should mention here, is not fast. It is not inexpensive. It is not sort of soft law or as I say, it's not mediation. Basically, parties, whether they're states or private individuals or both, go to international arbitration because they've agreed to do so, either by a private contract or in a treaty, because they're from different countries and neither one trusts the other's court system to resolve a dispute. So you should always remember that arbitration is borrowed from national courts' jurisdiction and therefore regulated by national courts to some extent. And I'd like to remind Americans in particular of the fact that one of the reasons international arbitration is better than international litigation is because of the New York Convention international arbitration awards are enforceable around the world. Close to 200 countries will enforce arbitration awards, and international court judgments are not. And the United States does not have a single bilateral or multilateral treaty allowing enforcement of court judgments. And this is what I like to tell Americans, one of the reasons for that is not just that we don't trust courts in other countries or think they might be biased or not sophisticated, other people don't want to come to our courts. Can you believe it? Not because they're not excellent, they are, but because of discovery, because of punitive damages, triple damages, and because of the delays that can come into play. So it's a mutual decision by default, if you will, to arbitration by agreement where there are international parties. So with that quick overview, I want to remind you of other fora that there are, as I say. There are international courts, not arbitration, but international courts. You all are aware, I'm sure, of the International Court of Justice in The Hague, which is part of the UN system. They do hire law clerks now. They do look for interns and law clerks, although they tend to be school funded. Betsy, are they all school funded at this point? NYU and other schools?
I think they now have some independent.
But that's something you should watch because the judges there are hoping to have more law clerk assistants. That's a very substantive job, just as it would be to be clerking on a U.S. court. There's also, of course, the World Trade Organization dispute panels, and there's the Law of the Sea Tribunal. Those are standing tribunals. I'm frankly not that familiar with how much they take law students or young lawyers. There's the whole new network since I went to law school, it's amazing, of international criminal courts. There's the ICC, the main ICC, which we'll see if they still have defendants after next week. Obviously, the United States is not a sender of employees, legal and otherwise, because we haven't signed the Rome Treaty. There's also the International Court, the International Tribunal for the former Yugoslavia and Rwanda. Now, those are winding down, but they are still hiring interns and legal assistants, and not for this group, but prosecutors from the U.S. and elsewhere. There are other criminal tribunals on an ad hoc basis like Sierra Leone and Cambodia. And as I said in my introduction, there will be more. In your lifetime, there will be more. And the only way to predict them is to predict that history will continue to produce violent disputes that will lead to criminal courts. One place to keep up with all this, by the way, is a website that New York University has for it's something called their Project on International Courts and Tribunals, PICT. I can't remember the exact website, but you can Google it. And there you can watch all of the criminal and civil tribunals international as they develop, and they post employment opportunities there. Besides the criminal courts, there are, again, a panoply of ad hoc tribunals and claims commissions, which is some of my background. The Iran U.S. Claims Tribunal is still going, believe it or not, but just for some big accounting claims, so that's not an option for you. The UNCC is wound down. International Organization for Migration just finished its German insurance and remembrance and Roma programs for World War II era claims, but keep an eye on them because there will be more. The Claims Resolution Tribunal for Dormant Accounts in Switzerland is also finished, but that is where I was a director. That was matching people or heirs of people who had money caught in private Swiss bank accounts before the Holocaust with claimants today. A very interesting rough justice sort of process. And then, as Betsy mentioned, I'm a commissioner on something called the Eritrea-Ethiopia Claims Commission, which is the first ever tribunal deciding civil liability for violations of the Geneva Conventions and international humanitarian law. We just had our last hearing last month. We're finishing up the damages phase. So it's not criminal violations, but civil violations with the idea of compensating civilian victims of violations of the law of war. Now, with those behind us, there are two sides to international arbitration. One is, and I'm going to leave this to Jonathan, the treaty claims, the public international law claims. It's ICSID disputes. There are UNCITRAL disputes that are treaty claims that are administered by something called the Permanent Court of Arbitration in The Hague, which is not a court, as usual. It's not a court. It's an institution that supports international arbitrations in the public and private field, and they hire counsel, the PCA. In fact, they often have interns, and a number of ASIL members have been counsel supporting ad hoc arbitration tribunals. There's also, of course, NAFTA cases that go on and energy charter treaty cases, and there you need to be either in a government office, in a legal advisor's office, or in a private law firm to work on those cases. There's not as many cases as there are people who want to do them, but by being already in Washington for the summer, I would say you have a leg up. Then there's the whole area of commercial international arbitration with the ICC in Paris, the London Court of International Arbitration, the AAA, ICDR. Again, we're in an area where your practice would mostly be law firms or in-house departments. And then don't forget there's really litigation for dispute resolution internationally, both in law firms and in the Department of Justice or other government agencies where, because there aren't arbitration agreements or treaties, there's lots of disputes. This can run the range from trade disputes to immigration disputes to infrastructure disputes to political risk insurance disputes. It's unexplored, I think, often by young lawyers who want to do international work. So what kind of skills do you need? I know Jonathan will talk about this as well. If you want to do dispute resolution, you have to be interested in resolving disputes, in litigation. And what we look for at Freshfields, of course, as I'm sure White & Case does, are advocacy skills, written advocacy. Most important is writing convincing arguments, setting out facts, setting out law, tying them together, convincing your judges the only way to vote is for you and your client. You also have to be interested in what I always call peeling back the onion of truth. You have to be willing to comb through documents, many, many, many documents, many times, interview witnesses, ask a lot of questions, really dig for the truth, sometimes 10 years ago, 20 years ago, recreate a situation. You have to enjoy that, or it will show. And it's certainly true that in international arbitration, public and private, we don't do discovery like you've heard about in US litigation. We don't have interrogatories and requests for admission and endless document motions practice, but documents and facts are at the core of at the core of winning a case. The public international law, fascinating as it is, or the private international law, is a small component of putting a case together. Now I'm really going to depress you again because I was teaching a course for Andy Lowenfeld on international treaty arbitration up at NYU this year, and the students asked us, what is the single most important course to take in law school if this is what you want to do? And without skipping a beat, as if we had rehearsed it, which we did not, Andy Lowenfeld and I both said, accounting. Depressing, I know. Accounting, because at the end of every case, if you get that far, is calculation of damages, and in the big cases we're talking about discounted cash flow analyses of expropriated investments that would have gone 50 years, and you need to be able to estimate what's going to happen to the price of oil and the interest rates and discount it back to the present and know how much, of course, oil would come out of the ground with what techniques, but you really need to be numerate and in order to work with your experts. So I wish I had taken accounting in law school. I have to admit I did not. And you also need an international outlook, of course, an interest in comparative law, different cultures, civil law, common law, be open to how other people think. And this separates out a lot of lawyers in the U.S. I think everyone in this room, by definition, assumes we all have that outlook. Everyone does not. Even in some of my tribunals, I have chairmen who are Americans who say, well, that's how it is. It's not a privileged document. And I say, well, it is in the countries we're talking about. And they say, no, it's not. So you need a broad outlook. Now, Freshfields, my group in New York, is unusual because we have a dedicated international arbitration group of about 20 people. We don't have a litigation group for historical reasons. So when I'm looking to hire, I generally hire laterals who have several years of pure U.S. litigation or foreign litigation experience before they come to us, because we can't do that training very easily in-house. I know White & Case is not in that situation. They have a broader practice. And the last thing I'll mention, if you want to go into this area, is you have to be willing to travel. Travel when it's not convenient. Travel longer than you want to travel. And I'll give one anecdote. A few weeks ago, I was doing a 2-week hearing in The Hague for the Eritrea-Ethiopia Claims Commission. And in the weekend in the middle, I had to leave and go to Paris to be an advocate, switch my thinking from being an arbitrator to being an advocate in an energy charter treaty preliminary matter hearing in Paris. And as I got back from the hearing, I guess it was on the Saturday night late, I couldn't understand why the key wouldn't work in my hotel door. I was getting impatient, and then I realized, oh, this is the key for my hotel in The Hague, not my hotel in Paris. And I said, my life is pathetic. I have so many hotel rooms. I don't even know where I am. But there's a good side of it as well. And tonight, in fact, I have to leave here at 7:30 to catch a flight to go to Istanbul, because our group is representing the government of Turkey in 3 big energy charter treaty cases, which require a great deal of work. I think it's about my 20th trip to Turkey in a year or a year and a half. Very challenging cases worth many, many billions of dollars. Similarly, another colleague of mine is on his way to Venezuela because we're representing ConocoPhillips in the expropriation claim against Venezuela and Hugo Chavez for the most recent activities there. But I don't do so much of the Latin America work because I'm not a Spanish speaker, so I'm extremely happy to turn this over right now to Jonathon, who does both.